person today. Available to answer any questions we have. So the primary purpose today, we know that the commissioners named some issues that they were interested in hearing more about several more. So prepared to respond to several of those and any others. Assembly sponsors are also here. Materials and ability to share those. I will try to speak up. I don't know why the. Thank you. And so we have Brandy online. So if people are having trouble hearing me online, yes, please do speak up. I'll just briefly go over the attachments and materials that we have, and mostly just to open it up to questions. We had a couple of topics that the new commissioners mentioned on the 18th. And so first of all, just to go over the materials. So we had a staff report and opened the public hearing on March 18th. The staff report had 5 attachments in the first 4 attachments are 1 through 4 were a part of the Assembly's home ordinance, several versions of that. And then there was a 5th attachment, which was comments received for the hearing.
The one dated January 12th, the most recent version?
The comments in attachment 5 were received by, let's see.
Yeah, between the, I just want to make sure that that actual.
The date of the text amendment.
Yes.
Oh. Attachments 1 through 4 were the versions of the home commission. Version recommendations on is an attachment 2. That's the S version of the ordinance. Attachment 3 contains some 4 amendments that were discussed to that version. Attachment 4 is the January 12th sponsors version of the ordinance. The sponsors version was developed after the Assembly referred attachment 2, so was not referred to commission by the Assembly. But attachment 4, the sponsors version, provides fills out some of the gaps that were in attachment 2. In addition to the 5 attachments, there's some supplementary packets. I believe supplementary packet
3, 4, and 5.
Yeah, there was 1 and 2, which were some additional public comments received. The date for just before the hearing. And then supplementary packet 5 is more recently received comments. So supplementary packets 3 and 4 contain legal opinions regarding zoning and the comprehensive plan of the legal department. The supplementary packet 3 is a legal opinion regarding whether the home ordinance constitutes a rezoning. The supplementary packet 4 is a legal opinion regarding mandatory compliance.
So for clarification, sponsors have not issued a wilderness referendum since the March 18th.
Right.
mentioned that there was a revised sponsors version that was not referred.
It was in our packet, but it wasn't the official thing we were meeting on. It wasn't what, a lot of the public comments were to the old version. So then they came out with a new version before that. It was in our thing. And so we're really shutting down. Just keep your dance shoe.
Let's declare there is a version that was just after first version of the book, and that sponsors version not been successful.
We saw them all together, though.
We did see the public comments. We could have just established the public.
In theory, if we were making a recommendation, we would probably be making it on their new version. Our recommendation would be go with the new version. I would guess. So it was in the packet.
I'm going to establish the public and the public record. If the comments that came in address that version, then we can establish there's a public record. So
Yeah.
can we, as a body, notice something that wasn't referred to us?
Tom, but I assume the most recent comments we received were for the substitute version.
These are in the packet.
Right, so there, I think there's a confusion about which version, but the assembly referred attachment 2.
Let me give a quick example. So we hear a case. Staff has recommendations. Those recommendations weren't part of the application, similar to their ordinance that they refer to. We might accept staff's recommendation, and that's what we end up passing. It's not what was applied for. It's what was applied for with staff's recommendations. Or in this case, we would be maybe passing some version of this one. So it's, in my mind, it went through the public process. If we pass it, it's essentially just a new version, an updated version. Kind of like, I mean, I've done this for my cases where I've applied one way, then I've got staff comments back, and then I've actually submitted new versions for the board commission to consider, and then they approve that. So it's not much different than just tweaking a rezone or a plat.
I just said context, who would call that a substitute?
Yeah.
And we as a body have the power to do that. I'm not questioning our ability to do that, and I certainly don't want to presume what action we might take since the public hearing is all open. I just want to, should we establish for the record what we have considered as body if and when we pass and what's out of the committee. Okay. Still open.
Yeah.
Done on purpose.
Yeah.
The confusion as to what was being acted on. Yeah. So anybody who's testified previously will be able to testify again on the meetings.
That's my understanding.
That's what was discussed.
Yeah.
I think that was the whole context of preaching. That's why we're here today. If we're flying at 1,000 feet without a parachute.
I think we're flying more at like 100 now.
No, sorry for this person. We'll do it. I appreciate it.
So, okay. Do we want to cover, do you want to briefly summarize these, or have you guys been able to see these packets that we have, the legal opinion?
Being prepared to get into the details of
Yeah.
the substitute version, or not the S version, but the sponsor version, I guess I call it, because that's what we encourage you all want.
Yeah.
Get into the nitty-gritty.
I think so. I'm just trying to kind of like work our way in there.
Okay. So we can respond to any questions you have on probably any part of it, or let you know if we have to table that question and come back with an answer, because it might be that we don't have our counsel here.
Yeah, well, I was gonna just follow our kind of normal format where staff does their thing. So if you guys have anything more to add before, otherwise I'm gonna turn it over to the petitioners, the assembly sponsors, and however I should be referring to.
Yeah, I guess I just have a process question, because I know we're sitting here not as, well, we're assembly members, right, but we're not the ones driving this meeting, so I just want to make sure that we're clear, which is why I'm not really responding to your, so just kind of guide us.
Yeah, I'm like giving these guys their chance to speak, and then I'm giving you guys your chance to speak, and then we'll probably the questions will roll.
As a work session, because some parties of the public listening in.
Yeah.
Are they able to speak?
I believe I believe if you wanted to ask them a question, you could. You look like this. So, okay, well, I guess,
We heard from the planning and zoning commissioners on the evening of and afterwards. There were several issues that were interested in hearing more about, which was learning more about the SLs. Another was learning more about the flex issue or possibility. The third was learning more about the commercial entitlements in areas currently zoned multifamily. Lastly, I think there was one more. Here to respond to those questions and then any others. But the main purpose of today is to find an opportunity to answer any questions.
okay, let's now hear from the assembly sponsor.
You wanting a presentation, or you wanting to ask a question? So it's really unclear. So we can present,
I guess my first thing, like
a specific zoning changes, because that's what we didn't get into.
I mean, I guess, is there any update? Have you guys done any changes or done anything with it since our meeting? I guess that would be, where are we at?
So we walked away from the meeting making a couple of commitments. One was for a work session, the other was to present comp plan and land use plan amendments. Those were submitted and referred, and there's a concurrent case to this. And so you all should have those, and they should be set for public. Current cases that moved.
Staff that see those.
Right, so for the comprehensive plan amendment case, packet, staff report. So you'll see for I think that will be next week.
Similarly, we had, I think, our attorney, Allison, talk about the that work there for public hearing tomorrow night. And it's not one that we're involved with. It's about our legislative process. And see where that goes tomorrow night. So we'll have a date for you about that ordinance.
Is that like a Title 21 code change?
Has to have the assembly initiate Title 21.
Like part of the chapter 3 stuff?
Yes.
That I read about 160 or something.
So those are the,
That's where, I just want to know what. Yeah.
well, and just to be clear, that's not, it's that comes more out of kind of all of the.
Yeah.
Process or separate member issues and code.
Yeah.
And so it is a separate piece.
Yeah.
We're not bringing it to the table.
Got it.
Just to be clear, it's trying to address that gap.
Yeah.
Just taking care of the to-do list that we walked away from the meeting with. So I'll sign the amendment, we have the attorneys meeting, come up with that process issue. We have not made changes to that we've been out copies for we're here ready to have the conversation.
I think, yeah, like, I think we're ready for Commissioner question.
Before we move into the detail, I'm just curious with respect to the legal question here, is that the only outstanding piece that needs to be resolved in your mind is the related ordinance that addresses the procedure? This question, with the case, I guess, as well.
The extent that it can be resolved, yes. Right, as to where you're saying.
Sure.
But I think that to some extent, yes. And I think we can, I'm sure that on the application of the questions that might. And I guess I would offer to, kind of the way we've been approaching this, to try to talk about the policy. But we'll start off with like a question / comment, which is, what is frustrating to me about this is this is a chance to address some of the things that we've been struggling with for 5 years, which is like a convoluted code that developers find it really hard to navigate. We find it hard to navigate. Staff also finds it hard to navigate. Like it's like, if you feel like this, it can be a ordinance, tell me, but I guess I'm interested in digging into things. Where does the bonus take come from? Do we need both the maximum lot coverage and the floor area ratio? How do we approach those questions? Would you feel like so from a policy perspective, what we did, for simplification, right? We have 15 zones down to 5, and we land use designation as the 5 names of those zones. And so when we combine them, least restrictive and that we didn't go into and we're substantially altering the other portions. So I don't know that it will solve all of the issues, but what it does is make it by which to approach those issues. So you would assume that things like that would be dealt with in subsequent. Correct. We didn't do no Title 21 rewrite. Okay. We took a chunk, sizable chunk, but something that was made with a particular policy.
I'll follow up with the previous question and answer. Two alternatives. We presume then that might come back with.
I have not seen this updated legal opinion until tonight, so I don't know if they've seen it and it's been updated. I would have to check with them on the merits. Allison, if they've seen it. I'm not sure. It's been on the case, PZC case for but I haven't. Rezoning one is not really any. I think I've corrected a few typos or things like that. So that hasn't changed from what they saw. Assembly Council saw. The comp plan one is very high level. It doesn't get into. It just says the basics of it is just the Anchorage Charter requires comprehensive plan, and therefore zoning needs. Doesn't make statements about the home initiative or the merits of the AO that the assembly had, the sponsors for that working on in this body to see. Very legal. Not much application. But, okay, yeah, I don't think our attorney is necessarily monitoring. But they had to update packet number 3 and packet number 4. Reviewing our comp plan and they went through our legal
I guess I'll just do one more follow-up, which is the bonus table does look here like it's been an addition into this. Is it been moved from a different section of Title 21 or?
And okay, sorry, I've been working on a sound issue. So are you referring to attachment 4?
I'm referring to attachment 4, page like 58. It looks like all of the bonus provisions are new. So I'm wondering, is this a cleanup thing where they could be moved from a different section? Were they added entirely here? Yeah, if you could provide a little bit more information about where these came from.
Page 58.
Yeah, yes.
I can answer as we're looking. I mean, generally speaking, the choices that were made were to relocate sections out of the individual zoning districts if that was appropriate. So, I mean, so I see what you're looking at, starts like page 56 of my copy. But yeah, we did not contemplate these new bonus areas. Like, we didn't make them up, so they were just copied from the different section. So, I mean, that's a policy choice to make changes to them. That's not a policy choice.
Yeah, I guess one of the policy choices was a little bit of reordering for ease of reading.
Have you guys seen Sean Debenham's May 1st comments? They're the last page of what we have as supplementary packet number 5. I read through them and I found myself in agreement with everything that he said.
So I know that was basically where I was starting to talk now.
So we do have them in our emails. I
Yeah.
just pulled it up. I have not had time to read it yet, so we just
I
received.
think he made some good stuff, but
Can I respond to one of them?
sure.
So going back to R and numbers, I think is a bad policy choice because they don't mean anything to the general public. R1, what is R1? So I personally like using the land use designations because they were words that had meaning versus a special lingo that only a small subset of the community understand. And I think it creates clearer expectations. That's not terribly technical, but to me, I think that's an easier way to talk about things. It would provide clarity in our code versus these R designations. Some of these are about the design standard. We specifically did not take up design standards. Again, we made a policy choice to keep this as a simplification of zoning and the combination of zoning districts. It doesn't preclude additional actions later. But right, we took the bite out of the elephant we could handle instead of a full Title 21 rewrite. And I understand there is a large desire for changes to the design standard.
Chapter 7 rewrite, just 7.
But that is not this current
Yes.
initiative, but again, it is a standalone set of policy choices we are bringing to you, but that don't necessarily preclude other things from happening in the future.
I understand. I guess, I'll move on to a different question, but I think I'll just maybe say as a comment that we would all really like to see that and fast.
Great, you should also talk to the planning staff and the planning department about that.
Oh,
Okay, I'll move on to asking, maybe Tom, if you could talk about the SLs. That was one of the questions, which was what this would do to any existing property that has an SL.
Sure. Just briefly go over what the proposed ordinance proposes with respect to SLs and the effects, the purpose of SLs, and then give you a couple of examples of some effects that the planning department saw that led us to believe that as one reason why recommended the commission postpone and allow the assembly, bring back a revised proposal. So first of all, just, so the proposal would merge zoning districts into fewer zoning districts. And many of these zoning districts, well, I'm sorry. So on the left are the current zoning districts and on the right are the proposed merged zones. And so what the proposal would do where there's a zoning district with a special limitation is that it would, for example, R1, the top zone, if there's an R1 SL, that the merger would result in the removal of the SLs from that R1 zone. And then that R1 zone would be merged with all other R1 zones into the single family, two family residential. So all SLs would be removed and all of those SL zones would be merged into one of the 5 resulting zones. And their merger, the direction they go, what group of zones they merge with is determined by that acronym. It's an R3 SL, it gets merged with all R3s into the compact mixed residential medium zone there in the middle.
How many existing SLs do we have currently?
So there are currently 105 residential zones in the bowl. It accounts for about 20% of residentially zoned land in the bowl. And they have a variety of purposes. They're a tool to allow more lenient use of the property than would have been approved otherwise. But the entitlement is the SLs ensure consistency with the comprehensive plan in some cases, or in other cases, to avoid adversely impacting the surrounding properties. So one thing about SLs is that they are regulations that burned right into the rezoning ordinance, so they're not in Title 21. And many of the SLs were created in the 1980s, right? Or even the 70s, the 90s, the 2000s. And so some SLs address concerns that people had back in the day, the 80s.
That's back in the day.
Okay, great.
That's back.
So that many folks don't have today. Some of those SLs, in other words, special limitations, are antiquated, and maybe they aren't a concern anymore. Others still probably are. But it is the planning department, the municipality, we don't have the authority to waive SLs any more than we do any other regulation. So it'd be up to the property owner to determine, is this a special limitation a problem for me today? If so, and to bring it back in the rezoning. So that's the current situation with special limitation. Here's some examples of special limitations. We mentioned these in staff report. So these are SLs that where the SL is actually makes that zoning district very different from the acronym. For example, the top one, number
R3,
R3,
Rabbit Creek.
yeah, which,
There's a large portion of the Eagle River that got zoned R3 SL also, but they function like more like single family.
right, and then the R1 ASL in the far right, in the map, that would function more like a larger lot district, like a rural. It's outside the water, wastewater service area.
Actually, a lot of Powder Creek does have some water.
Right,
Sewer.
and those areas are generally the R3 SLs. And so they really behave more like a single family urban zone or an R1A zone. The main thing they have in common with R3 in some cases is that the R3 was used by the applicant and the municipality at the time to allow maybe a taller building or to allow a greater variety of housing than single family, but still keeping to that single family.
Don't they have a strong and active homeowners association, so it could be irrelevant?
A lot of them do, but the question is when we do this, if there's an R3 SL, like this is, Tom and you, this is my guess, is that developers were going to R3 SL because they could take advantage of cluster plan that maybe R1 wasn't allowed to do back in the day.
Or taller height limit.
But I mean, a lot of these places aren't even yet to be developed, but either way, they look and function like R1s. They have CC&Rs that make them R1s, but they're called R3 SLs. And they're before my time and I don't understand why. But one of my questions was, what do those become now?
Take a crack at the way
Sure.
forward, which is, so the SLs ride with the property by ordinance, but they are not, how do you put it?
They're attached to the map, they're not attached to the property.
Except for by ordinance, so you could carry them all forward on the map by parcel, right? So you could kick the can down the road effectively and leave the SLs there, then take some time, right? And owners could take time to see what their new zoning district means and see if the SLs are applicable any longer. And we could work with you all to create a policy and a path forward for those where they're no longer applicable. They're subsumed into the more expansive zoning district, or they're old holdovers, where they could be removed, with maybe some kind of truncated rezone.
And that's fine if we have visibility to address those, but it's the unintended consequences that I'm concerned. It's fine if you've got visibility as to which ones you need to work. But there are gonna be so many, and it's gonna be the ones that get left out, that my concern is the unintended consequences that occur.
Sure, but if you first start by carrying them forward, right? So, because they're supposed to be protective, or they allow you to just do something permissive within the zoning district. It's two different ways. There are protective ones and there are permissive ones, I would argue. The protective ones are things the neighborhood wanted in order for probably a rezone to go forward. I was recently looking at a parcel in UMed, and the special limitations are around lighting and landscaping. Those are already required under code. They're somewhat obsolete. So there's those sections. And then there are the ones that are more permissive. So once we transfer all the SLs onto a new zoning map with the new zoning districts, that gives a parcel owner the opportunity to look at what is allowed in their new zoning district and to see whether or not those SLs even are functional anymore.
Thank you for explaining it that way. I appreciate that because that was one of my primary concerns with this, the idea that there are 105 SLs. First of all, I don't know where I would go to see all 105 of them and to review them, because I imagine that they were at one point debated, had some kind of public process, and they were, many of them with through planning and zoning were voted on as part of an approval like we saw recently on one. But my concern, as you mentioned, sometimes they are more permissive, you mentioned as well. And where they are more permissive than the zoning, and where they may even be more permissive than the new zoning that they find themselves in, that could be considered a property right. And so if we were to simply remove it, that would be potentially a regulatory taking. And to do that blanket on 105, without a deliberative process, I think could end us in some hot water. So, I appreciate that there is a carry forward of these SLs. I'm sure many of them refer to the old zoning, under the current regime. I don't know, I haven't reviewed 105, I haven't reviewed more than probably 3 or 4 that we've had brought to us. So I don't know the content of many of these. I haven't been around looking at zoning since, in the 80s. We've come a long way. We're also a young city. And will we have more SLs in the future? I don't know. This was kind of a policy question we had as a body earlier this year about whether SLs are a good tool to have or not. They're a tool in our toolbox, right? You mentioned that they carry forward with the map. Are we talking just about the 2040 map? Are we talking about, like, are they on plat maps? What are they exactly attached to?
The only place I know how to get them is emailing the planning department to get it from the clerk's office to get an AO.
Thank you. That's kind of.
You can go to the zoning map, find the parcel, and then once you find the parcel, then you can use the public portal for documents to pull up the old AO. But the AO is your record of the SL and what they are, and so if you carry them forward, you can still get back, right? Because the legal description that was rezoned that attached the SL in that ordinance is still there. And that's how you find the underlying ordinance. So you don't lose it simply because you change that zoning indicator. It's attached to the legal description, which you can then attach back to the zoning map. So you can close the loop even if you change what the zoning districts are called.
I'm sorry, please.
I think Anna will.
Yeah, I just want to add 2 things. One, bigger picture, I think some of these questions, and these are things that we have also struggled with, really, I've been describing them to the public in another context as well as an onion. The more you dig into this, the more complicated it becomes. And so the reason there aren't answers to some of these things is not just this ordinance, right? It's because we're trying to understand how things are done now. And I will say also, so I started digging into because I'm also a professional planner. I am not a practicing planner in this context. I'm not working for anybody right now, but I will say that special limitations are not a thing in planning. They are not, as we said, they're outside of the zoning code. The way that it's typically handled is special district or special use limitations, which are built into the zoning code and are not applied property by property. I've also asked our council, are these illegal spot zoning? Because the premise of spot zoning is that you treat one specific property differently than the things around it without a legal basis to do that, right? And it becomes arbitrary and capricious. The answer I've gotten is not that they are illegal spot zoning. So, reasonable people can disagree about that, but fundamentally as a policy, they are not. However, they do seem to be inching toward that. And so that is something that I want to ask, or just kind of flag as a bigger issue that I think home, as we said, we can carry it forward, but that is a separate big question that needs to be answered. Why are we continuing to do this? And why, and really, and again, that's not something we're here to solve today. And I'll offer just one other example of a special limitation briefly. We were looking at one in Government Hill. I actually was up there knocking doors the other week. It's a special limitation that says because there's the point about being more permissive. This one says that when you develop this particular area, the houses need to be at least 1,200 square feet and have a 2-car garage. So, when we talk about planning policy and entitlements, it seems like that took away entitlements. And that was the decision at the time, and it's in part of an ordinance, so it's law now, but I just want to put that on the table. That is the implication. And then as you dig into more of these, every single one of them has a story, and a lot of them have actually been, have allowed less housing to be developed than the underlying zoning allowed. So that's not the only situation, but I just want to put that out there, that is a pattern, and it is a choice that has been made over and over.
I like your analogy of the onion. But remember, the outside of an onion tastes different than the inside of the onion. And that's part of what this process is about, is to find out what's going to happen as we peel back that onion and get into the unintended consequences, the actions and so forth, and what, you can't unring a bell. And I think that's a lot of the concern. That's a lot of the concern we're seeing from the public. But again, onion does not taste the same all the way through.
I would like, if there are unintended consequences that the commissioners are specifically worried about, I'd like to talk about them, because I think that that's something we should have an open dialogue about, because you all will be making policy recommendations using your expertise back to the assembly. That's what the Planning and Zoning Commission does, and that's what you're relied on to do. We've tried to think through all of the permutations of things that could arise, but we're four brains versus more, thinking about it and things you've seen as your time on, as commissioners, because usually when things come to us, they already have your recommendation with them. So we've really been thinking about what are the unintended consequences. So if you take single and two family, right, you combine R1 through R2D with R5. What does that do? One, so it allows duplexes in single family zoning. So the question is, what could those unintended consequences be?
So let's take that as an example.
Could we stay on the SLs for just a minute?
yeah.
Pardon?
Mind? Could we stay on special limitations for just a minute? A clarifying question about consequences. So can you help me understand what the consequence is to the SL process? I think I'm hearing you saying that proponents would recommend carrying forward the SLs that currently exist. But what about the process in terms of it having been used to the toolbox? Are we losing that tool through this initiative?
Nope, nothing restricts it. I can tell you as a policy matter, so far the assembly has disfavored the last two SLs that have come forward. So whether or not it's still going to be a tool used moving forward, I think that's a broader question than the home initiative. It certainly doesn't take the tool out of the toolbox.
And it's in Title 21, so whatever section was carried forward since the 1980s that allows that to happen. So this doesn't touch that.
Thanks.
My question is oversimplified. And it's gonna be, I'm either gonna show my ignorance on the topic, or I'm gonna try to let the air out of the tires and say, we talk about tools in the toolbox, having the city, having the planners, having the group, having a tool that will allow this activity, your end result activity to occur is a great tool. This is one approach. What if they had a tool in the toolbox that let them take on the one-on-one cases that come before them to put that duplex in an R1 area? There is a process by which that can happen because we place new tools in the toolbox for the city to use.
It is one approach, and it's a set of policy choices. The policy choice brought before you is to simplify and consolidate zoning districts, because we think it feels a little bit like a Dr. Seuss house right now, all Band-Aid up with lots of things, because the tool in the toolbox has had to be modified so much. It's not enough. Zoning right now is not an effective tool.
But there's a path forward for this same action or the result to occur, because that tool now exists that doesn't now.
We
I'm
might
trying-
be
I'm trying
getting
to
a
get to-
little
I'm
too
trying to get to-
abstract, sorry.
I'm trying to get to the end result
If I
of the
can
same process
interject.
without creating a whole new rampant change in the zoning that has more potential for unknown unintended consequences. That's why they're down the road. We don't know.
So very simply stated, what we have done with this proposal is combine these zones and use the least restrictive portions of code, the least restrictive development standards as far as setbacks and dimensional standards, and the least restrictive uses in these zones. And those tables can be seen in attachment 1, exhibit A, this has a page number, and attachment 4, starting on page 41. So that is all we're changing. We're not removing SLs as a tool. We're not removing rezoning as a tool. We're creating by right opportunity. So right now you're saying an individual landowner could come in with an R1 lot, rezone to be able to put in a duplex, and staff by zoning, current zoning policy would recommend denial because that goes against the zone. By combining these zones, we are making that a by right use. So a developer would be able to walk in and get his building plans, and zoning review would look and say, yes, this is an allowable use.
So I could take a 15,000 square foot lot across in College Village, for example. In middle of these sections, because right now the only duplex are allowed on the frontage of Lake Otis and Northern Lights. But now I can go interior on a 15,000 square foot lot and by right, put a duplex.
Yes, because there's nothing substantially different on those lots that are currently allowed duplexes versus the ones literally across the street. They are similar in size, they're similar in neighborhood, they're similar in all ways, except for one backs up to a busy street.
I hear you. I can tell you the residents in a lot of these locations are gonna have a fit, and that's that's why we're seeing
She
pushback.
probably has heard that.
So that's the area,
I'm sure.
that's my neighborhood. So a couple of things there. Most single.
Now,
so
you do have a homeowners association that's inactive, that precludes,
a portion of that, yeah. So this does not take away homeowners
but it's
association.
an inactive homeowners
Sure,
association.
for that one, but there are a lot of active homeowners associations. It's actually hard to buy a house not in a homeowners association in Anchorage, it feels like. But I think when we're talking about single and two family in particular, we need to think about where R1, R2, through R2D and R5 currently are located. These are mostly built environments. We are looking at infill and adaptive reuse, meaning converting existing structures. We are not looking at full new subdivisions, and we're not looking at the reality of a tear down and rebuild in most instances, because it just simply doesn't pencil. That's just not the market we have. We do see that in the lower 48. I've been to neighborhoods where every small house is torn down and, they build it out to the property lines and you have these giant homes. I don't think that's the reality. I would say the other piece is the reality of what's happening on the ground in R1, and I like to use my own street. I live in Rogers Park on Ingress Street. The houses around me, my neighbor next door has a duplex. Must have been before zoning became a thing. These houses are all pre-earthquake. I don't know how he has a duplex, but he's got a duplex. The other house on the other side was a multi-generational family. 2 adult children and their spouses, and the mom and dad live there. One across the street, 6 men share that work different rotational things and then a cabin and 2 single family homes. So the reality on the ground is single family doesn't mean single family anymore. And we really would like our.
Or that code enforcement hasn't been active and enforcing the code or the zoning or the legal build in those areas.
And that's
Because
not
that's
like.
very common in Rogers Park, by the way.
That's likely
Because
not
back
going
in
to
the
happen
50s.
due to resources either. So what we would like is a zoning code that reflects the reality, that doesn't really substantially upend, particularly in single and 2 family residential. Some of these changes in the combination of zones actually are single zones and are very minor changes when we talk about compact mixed residential low, which is really just R2M. Compact with mixed residential medium, it combines R3 and R3A, and urban residential high, which combines R4 and R4A. We're not really making substantial changes. What we're adding in those last 2 is the opportunity for that mixed use development. I think the toughest one with potential unintended consequences is large lot residential, because we're combining the most zoning districts there.
So I appreciate the continued cycle back to consequences, and staying on that theme. One of the potential consequences I have concerned about that staff raised, and it is the intention of R4A and R3A and its development, and how that is or may perhaps not yet be addressed in the compact mixed residential medium and urban residential high. So vulnerable high density areas as they currently exist. How is the future of those being accommodated for in the home initiative?
Sure. Yeah, I mean, so a policy choice that we put forward that we do want feedback on is basically one, combining those 2 zones. And then the implication of that is one of them is a mixed use zone, allows some types of commercial uses, not all. So the list is specific. We're not changing the use table in a substantial way. And so we put that forward as a policy choice to say that if you are currently R3 zoning or currently R4 zoning, that would open up the possibility of having commercial uses. So, I mean, in terms of unintended consequences, it is interesting because we've been looking at kind of the consequences of the status quo, right? Which is that we've seen a fair number of housing units being built mostly by Cook Inlet Housing, because they're the only multifamily builder, it seems like, for the most part, currently operating, one of a few. They're building in D3 zoning. So they're essentially putting housing in business zoning. And we've asked why that is. Why not use R4A? Why not go through the rezone process? All of those things. One of the answers is it's more flexible to build in housing in D3, even with the major site plan review that's required, that is not required of commercial uses, than it is to build in these mixed use areas. And some of their properties, like the one downtown, for example, downtown has its own chapter of zoning code. They did put in a mixed use development. They built one in Spinard, the earlier phase that's already been done. They've had trouble filling that, right? And so, we've also talked about kind of the reality that when you talk about mixed use, there's vertical mixed use, which is in the same building, in the same structure. And then there's horizontal mixed use, which is the idea that you might have multiple buildings, or even you might have multiple parcels. You build some housing on one of them and then you build a business next to it. And so functionally, it's still mixed use, or Rustic Goat, right? I mean, Rustic Goat has one building that's a restaurant and it has one building that's 4 or 5 apartments. And so we are proposing that to be more responsive to the market, to give more flexibility in terms of, what particular projects people want to build, whatever mix that is, that we would allow that. However, we do acknowledge that right now the code has requirements for a certain number of residential units when you do that. And so I guess the question then is, has that played out, right? I mean, has it actually resulted in more mixed use development, or has it resulted in addition of housing units to the inventory, to the whole market in the city? And I think what we've heard is, again, vertical mixed use is not financially feasible for most people, and as I understand it,
Developers.
the financing and banking.
It's not conducive for developers
Yeah,
because they can't get the financing.
right. And those are the folks who are building.
So they build apartments instead, and then do the commercial down below.
But I guess what we're hearing also is the places that have built commercial, they found it difficult to fill those commercial spaces. And so, so there's, do you build it, and then is it actually functioning the way it's supposed to? And then again, is that a net positive if we're not seeing what our current codes require or are trying to encourage? And so we're basically proposing a different approach. Say if these are areas that we would want, that is more dense, that we would want to see more development, more intensive development, and where people can walk to some commercial use that is near them, which is the whole point of mixed use, generally speaking. We don't talk about industrial and residential mixed use, right? It's about putting commercial uses near residential uses. Then another way to do that is to simply say, in these areas, in these zones, we would like to see a mix of these uses within the physical boundaries of that zone, as opposed to on the individual parcel.
And I would remind you of, we recently rezoned, did we do it? Yeah, we did. Okay, sorry, I've mixed up what we did, but we recently did the federal archive site from R3 to R4A. And one of the arguments for that was to be able to make a potential development pencil. And right, R3 in and of itself, right, we've had multiple attempts at that and it never went. We can never get a developer to develop that site because R3 on its own, just the housing there wasn't sufficient. And the planning department didn't bring forward R4 for the rezone. They brought forward R4A, and they really said it would take that commercial element to make something pencil. Doesn't reduce the amount of housing that would be required, but it helps bring a full picture of what we're trying to give is a whole slate of options to make those numbers work. That's what we're trying to do.
Function of cost.
Mhm.
How much do you want for the property?
Yep.
You lower that price lower enough on that property, you can see housing.
But to go back to your point that I think you were making with your new code is, I don't know of any R3A or R4A that actually has ever developed. I've seen it get rezoned.
Yeah.
Do we know that any exist, Tom?
They're very new districts, and so we only have one parcel zoned R3A.
I mean, that was like new as in 10 years ago, right? Are you talking about Arlene and Diamond?
Yeah, that was
I feel like that
5
was
years
like-
ago. And then the R4A, we have 2 parcels zoned R4A at this point.
Yeah, Arctic and.
They're relatively new. One thing that distinguishes the R3A and the R4A from a commercial entitlement zone like the B3 or the RO or the B2C downtown zone is that the fundamental aspect of the R3A and the R4A that places them in the residential column is that they have a requirement that the primary uses of a lot include the development of residential dwellings before the commercial space on a lot gets to see a certificate of occupancy. And the R3 and the R4A, that's what makes them residential zone. And so without that requirement, the R4A, for example, has an allowed commercial use table that's very similar to the B2C in downtown. The B2C allows a few extra uses, allows like civic centers and major entertainment uses, funeral homes and a few other things that the R4A does not. But what distinguishes the R4A is that it has a residential requirement. And as the planning department reviewed this, we do see a trend throughout the country to allow more mixed use in residential zones, to allow home-based businesses, to allow accessory commercial uses, even a storefront in front of your home. There's a lot of stuff going on. And even the corner store, and bring back the corner store, make it legal again. But in those movements, what we don't see is the full conversion of a residential zone into what I refer to as a commercial entitlement zone, where there is no use-specific limitation on commercial to fully use the lot. And I'd like to bring you an example of why we even have an R3A and R4A. Why didn't we just go with the B3? This is just one example, but it was one of the sources of why we developed an R4A zone to allow commercial, but still require the residential. It's an example of an R3 zone mobile home park. Most mobile home parks large ones are zoned R3. That was rezoned to a B3 SL that even required residential. At one point, it was revised to not require the residential, but it did not require the residential to be built first or alongside the commercial. So the commercial was built, and this is the Center Point office towers on C Street. But there still is no residential. Now that was 300 dwelling units in a mobile home park. And one of our concerns is mobile home parks, they tend to be R3s, they do tend to be near arterials. And we're concerned about the land use entitlement to convert those to commercial with no more than a, zoning permit wise, a land use permit. Several other examples. We have an RO district, and it doesn't require doesn't allow a very wide range of commercial uses, even a less of a range than the R4A or the R3A allow. The RO district, like the B3, it on average, even though like the B3, it allows high density residential. Like if you have an RO site or a B3 site, you can develop really high density residential. You have that permission. Because commercial uses are allowed, on average, what we see through the district is that the district overall develops producing fewer residential units than a multifamily zone. So on average, you see the B3 performing on par with a little bit better than the R6. The RO is interesting. The RO zone has properties that are off the main streets. They allow medical or office. They don't allow standalone retail, but they allow multifamily. And they are producing fewer units dwellings per acre than the R3. So what we've seen in the RO near downtown, for example, west of downtown, you have former homes being used as doctor's offices, medical offices. Like you could take the R4 zoned area of Fairview, southeast of Cordova and 9th, near downtown. And we have concerns about those kinds of areas becoming attractive for offices, conversion of developed dwellings to offices, or conversion of dwellings to apartments. Near areas where, other areas where we've seen the expansion of non-residential into residential areas through rezonings are near expanding institutions, medical institutions such as the 42nd Avenue area near Piper Street. So what we see is a positive to that the home initiative is recommending to make the residential multifamily R3 zones more flexible. But when we review the comprehensive plan, we see the greatest policy risk in the conversion of land supply or even dwellings to commercial only use, whether it's lodging, an office, maybe retail. What we would recommend is focusing the home ordinance on the housing improvements. Like if there's something about the R4 zone or R3 zone that is not flexible enough, whether it's dimensional standards, focus on those. But to take a more to take an eyes wide open approach to allowing commercial. So what the mergers do, as described here today, is that the mergers take the most permissive zone and apply its regulations to the other zones it's merging to. So the most permissive zone would be R4A and R4. So take the regulations of the R4A. What our concern is, planning department, what we would like to see change is the current draft proposal isn't actually taking the most permissive zone, it's changing all the zones by removing the standards in R4A and R3A and ensure that residential. We would like to see a kind of a.
I'm gonna jump in here. I tend to agree with Tom, not because I don't think I'm like worried about this happening wholesale, but the R4A is just a very new zone. We really haven't seen it tested. I don't think I've seen a single R3A case in like 5 years. I think we saw the R4 come before us to be created, and then we saw one case. And really the comment I have to make here is like, I can just foresee this pushing us straight towards SLs, because when we see, this is exactly the case that we proposed in SL this year, right? Is we saw something come forward that looked substantially commercial, and then because of the surrounding uses and the description of the zoning district, we felt compelled, I think, to create an SL that created some residential use, right? So I guess I would say like, what I'm hearing you say sounds a little bit different than the description of urban residential high on page 20. So I guess like some more clarification about what the intention of that is. And then I would feel more comfortable, I guess, with just the R4 standards, because we know how those play out.
So a couple of things there. One, on the center point example that was given, that's poor enforcement, quite frankly. That's not a zoning problem. That's if you require residential, don't just let it all become commercial. That's an enforcement.
If you own that building and you own this building, then you can make things.
Well, so one, that's an issue. Two, we did an R4A. So we did the rezone of the mobile home park that is at Benson and Arctic. It's a Debenham property. And in that, there was a concern about losing a number of residential units because it is dense in there. So in that rezone, we made as a condition of the rezone, and it's not a special limitation, it is a finding, it had to be a 1-for-1 replacement. You couldn't end up with less dwelling units in terms of density in the end. So there are other tools to protect against some of the concerns, I think, being brought forward by the planning department. And that was a mixed use district. I can't remember if it was 3A or 4A. Sorry, it was long enough ago. Additionally, we can put language in about concurrent development. We certainly can do that, and each rezone can certainly take that up. I think it is short-sighted to take out the mixed-use opportunity. I think the mixed-use opportunity, what we're hearing from developers and why R4A was created, is to give that opportunity so that there can be those commercial uses, bring back the corner store, whatever it takes to make something pencil and go. Now, does that corner store in that development have to be attached to a dwelling unit? I think that's where we could be more creative and where we are trying to think outside the box. You know, worst case, you go back and change the code. But to start from that restrictive posture, I think quite frankly, out of fear or things that didn't fully get enforced or other reasons, I think is the wrong policy choice to go when we're hearing. You have to combine residential and commercial in some of these higher density places to make them pencil and go. I don't think there's also a lot of huge undeveloped land as well, where you're going to suddenly just have a takeover of commercial uses.
If I can add to that, one of the problems with R3A and R4A, they weren't part of an area-wide rezone. They're upon the landowner to seek that out and go through the rezone process, right? So that's why it's been sporadic and there have only been a few properties. With what the home initiative is proposing, it's opening up all the currently zoned R3 and R4 to those opportunities for the mixed use.
That would make it a lot easier, but I feel like I need to add on this whole R4 conversation, a developer's perspective, is that you don't see the buildings that R4 tells you to build, you don't see those getting built. Before I was on the Planning and Zoning Commission, I was on the HAN Commission. The HAN Commission reviewed low-income housing tax credit projects. And since then I've developed those and I've, volunteer on the groups to judge them. They all apply, they put in applications and they compete for points. What you're seeing for the low-income housing tax credit project, the most affordable thing that they can build, they've started pushing, Anchorage-based projects are pushing into Eagle River and Birchwood because they want to build townhouse style, because that is the most affordable way you can build housing. And this whole hanging on to this R4 mid-rise building, we're hanging on to nothing. There's no there. Cook Inlet Housing can do one, and Debenham can put something up downtown. But you don't see that stuff happening. And the town, our housing stock is old, approaching its life end old. And so that's the fear, is what we need to figure out is how are we gonna make more houses? Because nobody's replacing the 3-story apartments. I don't see that happening anywhere. I mean, correct me if I'm wrong, but that's where, for me, I'm I don't see why we need to hold on to R4, something that doesn't, there's nothing happening there. Nobody's gonna redevelop. They're just gonna try and keep the paint on the wall long enough to squeak another month's worth of rent out of it. That's what's happening in our R4s and our 3s. And
just a clarification on the, in this case, it wasn't an enforcement issue. This is a conforming development. And the key issue is that the residential requirement was such that it didn't really say when the residential is required to be built.
But did you say the SL was removed since then?
The SL was removed and it made it more like a commercial entitlement zone where the residential was allowed but not required. So the whole idea of the mixed use R4A, R3A zones is to allow commercial and still require the residential be built alongside or first. and to ensure a certain percentage of the site, or percentage of the development, excuse me, the space in the buildings be residential.
It's a perfect example, like Anchorage's two most successful businessmen. They have that land there. When they build residential on that thing, that's when you'll know, like, okay, people are gonna start building R4 here. It makes sense now. One of the other problems with housing Alaskans is that they want place for boats and bikes and things like that, dogs.
Chickens.
So,
The question I have is there, so one, you can make the recommendation that we required and retain the residential required. That's fine. I mean, we're open to that. That's why we're here. You get to make all kinds of recommendations, if that's what's necessary. I guess my question back to Planning and Zoning Commission, does urban residential high or compact mixed residential medium, does it preclude zoning or does it preclude development? Does it make development harder? Because that's what we're trying to do, is get out of the way with these zone consolidations. And so that would be the question we would ask is, are we making it harder for a developer to access those zones by combining them?
so a good response to that would be, it's from the development community, it's very difficult to read an AO like this and know if it's harder or not yet. Even once it's written in the full body of the code, I mean, we just had this recently on the site access. I read something that I thought my building met code. Staff read something and said my building didn't meet code. So really, the rubber doesn't meet the road. You don't know if your wheels are on the road until you get a building permit plan review. Because that's when developers will know how it affects them. Because it's vague enough to, like, you can read it and think that it works for you, and then somebody else reads it and it doesn't work for you.
Well, as policymakers, all we can do is try to be as specific as possible and get out of the way. Right? And so we don't have anything to do with the implementation side. So I guess that's where the unintended consequences come. Do you see something in how it's worded or laid out by combining R4, R4A and R3 and R3A? I've heard Mr. Davis's potential unintended consequence, which is the center point development. So there could be a recommendation for us to make a change to avoid that unintended consequence. But I think that's the posture in which we have to take it. We can't know how it will ultimately be implemented. I mean, the implementation should be to treat R4 and R4A the same.
Yeah, my impression is that it will become easier and more flexible. But I also think we need to, it's almost like we need to have it written in code and reviewed for permits to find out before we just throw out the old code and make a new code, because this is a big change.
I'd like to just snag one small piece of the consolidation of the larger residential zones, and that is the height allowances. I was at a community meeting in my neck of the woods up in Mountain View recently, and in winter time, we have low sun angles and all the commercial elements are along one street, and directly to the north is the residential areas. And the R4 and then the R3 as you go further north. And we can give height entitlement to a zone. I don't know how you ever reduce it without it being a taking. So once you've granted that, it's essentially a property right, my understanding. Now there are some things to be concerned about, and obviously feasibility issues like being in the accident potential zone for airports and those sorts of things. You're never going to be able to realize those rights. However, that argument didn't really ring true to me personally until this past weekend, when my neighbor decided to put up two 200 square foot, 12-foot tall sheds right on my property line, and I no longer have a view of the mountains. And it's something I voted for this year to allow. And it sucks.
12-foot high?
Two 200 square foot, 12-foot high sheds are allowable on the property line in the setback. It wasn't allowed a few years ago. So I care about it now because it's directly to the south and to the east. You know, I'm not gonna have sun in the mornings anymore. But that's a small thing. When you start allowing entitlements for height, it won't happen today or tomorrow or for a few years, but at some point there's gonna, hopefully in an R3 or R4 zone, be that density that we are zoning for. And it will eventually have an impact on adjacent uses. So I just would like to leave that to be considered. You know, we are in a northern climate with a higher latitude, and solar rights are something that was brought up during the ADU ordinance. There seemed to be, you know, I think we put a pin in that to come back to it later. And I don't know that's really defined anywhere. But I think it's something important for quality of life.
I think that when you're talking about R4 in particular, and you're talking about urban residential high zoning, where we have underbuilt in those zones previously and people choose to build to the density allowed, I think that's hopefully an inevitability. That is the only way we start to shrink the delta on the housing scheme. And that is living in a urban environment. I fully take your comments about living in a northern climate where it is very dark and the sun is precious. But that is also then the argument for possibly extending amenities, particularly outdoor amenities, to those places that are the highest density. So I think there are other ways to address it through investment and other things. I don't know that zoning and height restrictions are the be all end all policy choice for addressing access to light and space. And because if you go to bigger, more built up cities, that isn't something that is available in some of the densest areas.
I guess I've never been to a built up city above 60 degrees latitude, so I would have a hard time with reference for that.
I don't know I don't know the latitude. I was recently in Helsinki. Buildings are built on top of each other. It's a place that gets cold and dark. Further north up in Oulu in Finland, again, very close together, high buildings. The European style of building. So we do not have solar access rights in our code right now. And if that's a place that someone wants to go, then I guess they should.
Do other communities have that in the United States?
Yes.
Some do.
Anna,
Yeah, just adding a couple of things. Yeah, I would love to see, because I know there's been discussion of codification of those rights, and I've heard it's almost functionally impossible because of the movement of the sun. And so there's a question of how you draw it, what time of year you're codifying, right? And so I'm not convinced that it's practical to do that, but I would love to see somebody do that, because we circle around that question we have for decades. So we should either decide if we're putting in a code or not. That's my perspective of it. And I don't know that it's feasible to do that in a way that isn't completely a taking of other people's property rights around it, right? So if we all agree that we just want low density development, then we should also maybe stop trying to increase our transit ridership, or we should stop talking about compact housing, walkability, all the things that basically require buildings and people to be physically closer together than they can be in what is, a more suburban development pattern. So that's really the crux of where Anchorage is. I think. Are we a city, or do we just continue to be a suburb?
if a 12-foot shed is gonna make me not see the sun ever again, then we can throw this out right now, go R1 everything, 50-foot setbacks on all lines.
But the thing I also wanted to say about Mountain View, because a lot of the feedback we've gotten basically is going back to our land use plan. So we've looked at the maps, and a lot of the feedback is, why should we allow more density in more places or everywhere? And I'm using others' language to characterize, so I'm not saying we're doing equal density everywhere. And they say, why not put that in places where there are already the most, for example, bus riders, people who don't have cars. And some of our maps actually say we should put more housing density where there is already the most density of transit riders, for example, which happens to also be the most density of where people live. And I'm looking at the map of Mountain View. The zoning map of Mountain View is basically almost all R3 and R4, north of what you said is that business corridor. There's a little bit of R2M and then some other stuff. And then on the south of the highway is a different area.
We used to have 2 bus routes, and they were the most profitable routes and the most profitable stops in the whole city.
Yeah.
But then the city has deleted one and never returned it.
Well, just to go to the Mountain View and larger Title 21 question, like when I saw this first draft, I looked at the dimensional standards and was like, oh my gosh, you can build bread box 8 boxes up to the lot line again, like the one I lived in on Peterkin. And then I called Andre and he was like, actually, you can't do that because of driveway standards and all of these other things.
Are we
right?
limited parking?
Yeah.
Park in the lawn.
Uh-huh.
But that was my first reaction,
Coming
right?
back.
It's like
It is.
looking at this and
We gotta move the boat.
so there are other pieces that interplay with what we're looking at here to make this work for us in 2024.
And I guess my point is our underlying plans basically say, keep putting more housing in the places that are the most dense. And that is also what our zoning maps seem to say, and a lot of the policy choices that are in our land use plan. And so what we are saying is maybe we should think about other parts of town instead of continuing to concentrate, doing targeted rezones in certain areas, which by the way, already have the most people. And then it becomes an equity question of where people are.
You're going to see solar become a much major issue probably in the next 3 years. And what's gonna spur that is Chugach. Chugach has a solar farm on the plans, on the books, ready to build. And they're gonna sell, I'm gonna call it like a condominium. They're gonna sell shares in so much of the panels to the public. But that's gonna create a resurgence of interest in solar panel activity, and people are gonna say, why should I participate here? I want to put it on my own house. And this is gonna be a compounded, oh, I can't because I've got a 12-foot. Can't put it in my yard, can't put it on my roof and so forth. But I think you're gonna see a much major resurgence of solar interest over the next 3 years.
Just one last question to circle back on the SLs. Is your opinion that any change needs to be made to this version to carry forward the SLs?
We didn't address it explicitly, so there would probably need to be a line in the ordinance, probably by amendment at this point, or an S1 version that says it's our intention that they carry forward per parcel on the zoning map. Just as clear direction. So if this passes, that's an intention. So that way, as the ordinance and the zoning map is officially being updated, it's very clear that that's where they are.
And another one, while we're on the subject, you would like us to make recommendations on attachment 4 version.
Is that the detail one? Yeah.
Yeah.
Yep. And one of those recommendations could be, implementation times, staggering implementation, code overlaps, those types of things.
The SL zones would remain under the current code with the, if you have an R1 SL, it would have to remain under what they call current code, which contains an R1 zone. So you would think they would effectively remain, like we have the totem theaters in the B4 zone. There's no B4 in current code, so totem theater lives in an old zoning code book. Right? Because that old zoning code book has the B3 regulations in it. So those SLs, they would remain under what today we call current code. Because it's an R1 SL.
Ask a clarifying question about that.
Yeah.
So I know there was a Title 21 rewrite about 10 years ago. And I hear you that maybe there were zones like B4 that don't exist now, and so that was carried forward. What happened to all the other SLs that were in R3 or in all these other zones that fundamentally didn't change as part of that rewrite?
They're still the same.
But I guess that's why I'm understanding.
Right, those zoning districts were carried forward, like, for example, the R1 and the R3. Those 2 zoning districts were in that old code book, and we carried them forward in the new one. And so those zoning districts came along with that, right? It was only those zoning districts that were discontinued. The B4, the D2, which is Penland Mobile Home Park, those areas live in the old code book. And so
I think there are more policy choices, and I think we can probably bring those on the 20th. One way we could do that is we can talk with council to make sure it's appropriate, but we can give policy direction that the underlying ordinances and that they're expressed on the zoning map still move, and the zoning district actually change to the new things. They're still gonna be stuck with the SLs. It may just take more work. I dissatisfied with the idea that we have to keep a portion of old code for particular lots where an R1 SL is now restricted in some way beyond its SLs from being a single two-family lot. And that for some reason it lives in some old antiquated version of code. So I think we can explore that more. But the intention would be to carry the SLs forward in a way that makes sense. And we can lay some of those options out by the 20th.
I don't know how long we want to go for tonight, but, are there anyone else want to get anything out there?
I do, more programmatically, and apologies if, this has already been asked and answered, but, in the effort to develop where we currently sit with this initiative, what level of analysis, if any, has been done in terms of future outcomes? So call my question GAO related, how much does this bill cost? But instead, how many housing units, do we gain or lose as a result of the policy framework that's being developed?
So zoning in and of itself doesn't create or eliminate housing unless you are eliminating housing zones.
I appreciate the clarification. However, let's talk about the intent of why we're all here today, right?
Yeah, so the intent is to create flexibility so more housing can be developed. And so it's somewhat speculative. So because, right, you take R1 and you combine it all the way through R2D. So you take all R1 and you make the option for adaptive reuse. How many people will take advantage of that? I don't know, right? So I guess I'm not
I would
sure.
argue that some level of analysis and projection could have been performed, or could be performed to give us some idea.
That's a good, you raised a good point, because as a developer, land is one component of the total equation of building. Building cost alone, I don't care if people had empty lots, they owned them outright, owned zero. They still couldn't afford to build on those lots because the price of construction had just escalated so high over the last 3 years. It's just now coming back down into some realm. Are you seeing that as a developer, as a single family builder?
Think what?
The cost of construction.
Land prices are going down.
Yes, they are.
Because everything else has gone up. And
That's right.
land is the only thing that can get.
I'll take a stab at, I think you're trying to get at the metric, which is the price per housing unit. Does the allowance of additional density on more land? Because you have a set cost to develop. Your foundation is going to cost roughly the same if it's the same footprint. And you're going to have roughly the same roof. But when you talk about more housing units in between, are you reducing the cost of housing units? Are you making more affordable housing? You know, there are ways you can measure it. And I understand where you're trying to get at is from an empirical investigative, there's got to be a way that you can study this and you can project based on demand, income levels, sales trends, what housing is most in demand, and potentially how do some of these changes help fill some of those gaps.
Well, I would say that
appreciate
the Planning and Zoning Commission has a clear role here, which is that the last time the city did a housing study was 2012. And that is something that we could recommend that they update.
Well, it was updated, wasn't it, since 12?
For the 2040 plan, we updated the capacity.
Yeah,
Yeah.
but is the question like, oh, we have 10,000 R1 lots that you can now put 2 units on, so that gains you 10,000 right there? Is that kind of the question?
That is one approach.
Yeah, the base.
Yeah.
Yeah, I guess I don't know how you want to analyze. I mean, we can go back and do something. I can do like the R1 calculation. We think that there was a white paper produced how long ago? Well, when we had that, about a year ago in May, that talked about changes that could result in additional housing units, and it included zoning reforms. Nolan Fauda's also put forward some information about that. You know, does it come up with a direct number of units? No, because that's somewhat speculative. What we're simply trying to do is if we need 25,000 housing units in a municipality, how do we start finding ways to close that delta? And each housing unit is a housing unit. You know, I think it's really interesting to think about that the single most number of housing units kind of put on in a year were the hotel conversions converted, and then you don't capture those, right? Because our data also becomes incomplete because building permits weren't pulled for those. And so I feel like it's a squishy thing somewhat to talk about unless we want to define the parameters in which we want to do the analysis.
And I guess I'll add two things. One, kind of the general, I guess, philosophical approach that we've taken with this, and I'm getting back to numbers, but I mean, just the general underlying principle of all of this is let people do more with their property, period. And that basically the way that we're going to meet our housing demand is to some degree, maybe public investment like tax incentives, which is expensive and shifts the tax burden to everybody else. So that's a policy choice. We can heavy-handedly direct and enforce and say you're not allowed to build anything but housing on your property, or you're only allowed to rezone in certain areas that our land use plan calls for, you know, and basically enforcement. You're not allowed to build a self-storage unit at the corner of Diamond and Jewel Lake, right? I mean, because the plan didn't call for that, and that doesn't add housing, and it's actually a really great place for mixed-use development. That's not what we do, right? I mean, that's the general approach to letting or to addressing land use regulation in this town is to make plans that say really nice things, not necessarily enforce them, and then to continue to add regulations that get in the way of our actual plan goals. I mean, and I know I'm editorializing here, but that is kind of the history that I've seen play out. And as a neighborhood person and watching developments and the reactions to those and what happens as they move through the entitlement process, often we end up saying you can build fewer units than you started out with. That was the story of the Carroll Creek subdivision of the Eagle River, for example. So that's why we are where we are to some degree, is that we have disconnected ourselves from the intent of our plans. We don't carry out the intent of those. We don't use heavy-handed things because I don't think that's appropriate. I don't think the community would support it. But at the end result, we're basically getting in the way of the market, trying to do what people individually or as their business model are trying to do, which is build and have more housing units. So getting back to the numbers, I think we could do that. I think it's interesting. I've been digging into some of the background documentation on the Title 4 rewrite, or sorry, not Title 4, Title 21 rewrite, that took about, 15 years or so or more. There was analysis done. There was actually competing analyses done. One said that this will not have a negative impact on the development, on community environment, the cost, all of those things. Another one said it would add about 10 to 20%. And so I think as we've watched the real world implications of what the decisions were made, 10 years ago now, what we're seeing is not just that, but that has contributed before the cost of construction went up, before there was a recession in this town. We saw a decrease in what can be built. And we keep hearing, we, the assembly members, keep hearing from the development community that all of these things get in our way, right? And so that's the other thing, is I feel like we need to also at least put on the table, what is the analysis of the current regulatory structure that we have? Because I think it is fair to say we need to ask, what is the impact of this change? I think we don't ask, what is the impact of decisions that have already been made? Because what we keep hearing every day is that they are harmful, that they get in the way of the business community, that they get in the way of individual property owners trying to do things with their property, and that cumulatively, we are never going to meet our housing development goals that are set forward in all of our plans and our prior assessments on the path that we're on. And so that's what we're asking fundamentally, is can we try a different path?
I just want to add, I don't know how many of you saw the BOMA numbers from January, but 2023, just a little over 200 housing units built last year. That's a terrifying number. And quarter of those were block 96, which were, not even a market rate development.
Yes, but what we don't capture, right, which also happened the previous year, were 200 and some converted hotel units that were also housing units, right? So we also have to talk about, but what we do know and what Anna is referencing is after the Title 21 rewrite, you watch the building permits hold and they just plummeted and they've stayed low. So the question is, how can we, if that's one of our metrics of housing being built, how do we increase that? And not just zoning, it's other ways. I recently had a constituent reach out who's trying to do an infill development. You know what the solution to his issue is? Is an ordinance drafted by planning and zoning that waives your guys' review and comes to us for a quick fix so he doesn't miss this building season. And it's like, it's really cumbersome versus changing the fundamental flaws that exist that prevented an infill development from happening.
That's called for.
That's called for in our plan.
Every goal in our plan says we want more compact housing, more infill housing, and a diversity of neighborhoods.
So 200 homes, 200 building permits. Okay, good statistic, good number, numbers are down. The question I would have regarding those 200, what's the average cost? What's the average building permit? Are these $900,000 homes or are these $300,000 homes that are being built?
There's no such thing as a $300,000 home, so we could definitely wipe that off the
Well,
table.
but if you read the comments in here, that's what everybody thinks they're gonna get.
Well, there's no, yeah, I
They
mean,
think they're gonna get these infill lots.
yeah, no.
Because I'm a school teacher making $53,000 a year. I mean, that's some of the public feedback we're getting, though people are promoting, we need this, they're not gonna get it. So, those 200, what are they building? $750,000 home, $1.2 million?
I mean, I think that's the follow-up part to this is we have to recommend that this is a piece that, and then we need tax incentives and we need all these other pieces.
Because no one's building $300,000 and $400,000 homes.
There's just that reminder though, that those who are priced out of the housing market now are holding rental units, right? And so it cascades down and we can't cascade up until we open up housing at all areas.
And everybody I know that had an empty unit and so forth is going this summer, it's not for rent, it's for VRBO.
Well, some of us brought short-term rental regulation and it failed. So, I don't think that you can just take that posture when we know we need housing.
No, I get it, but that's the reality. That's
Yeah, and
happening.
the reality is we converted 271 hotel rooms into housing units. You want per door prices, $79,000. But that's a steal because it's a 6.5 year payback using HUD standards. They're not captured in the numbers. So how do we get from something that's there and this $700,000 or $900,000 home? How do we start to fill in all the way along the middle? And we think this is one of those tools, just one amongst many.
And I think this is a tool. I think this is a huge tool. I just wish we could take it and put a microcosm in it and, I hate to say this, to put a stamp on it, take it out for a spin to see if it's gonna work. Not a wholesale across the board, the Anchorage Bowl area, but maybe we regionalize this, incentivize certain locales and so forth, because what's right for the hillside isn't right for Midtown, which isn't right for West Anchorage.
Well, it could be right to build a duplex next to a single family house everywhere else in town except in my street, Greg.
Not in NIMBY.
So,
But
I think that's what you're gonna see, that like there's.
well, we're already seeing that because it doesn't apply to Girdwood. It doesn't apply to Chugat. It
Yeah,
exempted them. So it's not in their backyard.
yeah, I mean, then that's a good question. Is there any appetite to expand this to Girdwood and Chuyak?
So I would say those are different chapters of code. One
Yeah.
thing we discovered is actually they're basically bootstrapped on top of the Anchorage Bowl. So one way that we solved that was not to say we're changing 3 different sets of land use regulations at once, but we are holding the old code, and I guess maybe that's what we have to do, is just keep the entire old code, both of the old codes at that point in code. So we're recommending that those are different because they're not subject to the 2017 land use plan, or the 2040 land use plan that was adopted in 2017. Chugack and Eagle River have their own comprehensive plan, which I think wasn't updated since 2007. So that maybe is right for a conversation. Girdwood's plan is from the 1990s, and they have spent several years updating that plan. And I know they want to look at housing, and so I think that's its own conversation as well. So I think we're open to that, but to the extent that it's 3 different sections of code, it's 3 different communities, 3 different comprehensive plans. And none of us are from those areas. We saw what happened last year when a member of Eagle River tried to make those changes area-wide, right? And so I think it's a good conversation. It's outside the scope of this right now.
And Girdwood's underlying zoning is already much more dense than the Bowls. A lot of it is.
It's,
It's more permissive, I guess. Maybe not dense, but it's more permissive.
it's very confusing.
Yes,
because
well,
like-
that's every, well, they want to.
You can have a GR2 lot, a two supposed to mean duplex, but you have to have 16,800 square feet to build a duplex. There's only like 4 of those lots.
The only common thing I hear in Girdwood is they're building what?
But there is
do
no,
that?
there's no land in your, but they are, that's the land of buy a $500,000 tear down.
Seems like we're kind of wrapping up, but I wanted to, since we're not in a formal planning and zoning meeting, and this is very much a work sessions collaborative, and so I appreciate the opportunity to just raise this item. I feel like the vacant, abandoned, blighted, severely substandard housing in a municipality, which kind of piggybacks on the chair's comment of, that we're so far beyond the useful life of many structures in this town. It's a reality that's getting worse every year. The average age of our housing and the condition, I see it every day when I show houses. I showed 8 houses over the weekend. And it never ceases to amaze me, the stuff that flies, at the prices it does. And the prices aren't going down. And those homes that are severely substandard continue to go up in value and they're gonna sell. But there are so many vacant units and there are so many bank-owned properties and just eyesores in communities, particularly in the more dense communities. And I realize you can't solve all the problems in one ordinance. I get that, but I would like to see, you have to have a carrot and a stick. There needs to be some kind of an incentive. I don't care if the community, this is a policy call for the assembly. If there has to be an incentive of the private market to somehow redevelop and put non-functioning properties back into the housing supply. I'm not gonna say how to solve that, but I looked at the census data for North Mountain View, specifically in the 2020 census. There was 365 vacant housing units in that neighborhood alone, and we had 3% vacancy across the community. And they're just entire buildings that are abandoned, and you can go, there's streets where there's 4 or 5 fourplexes, they're all boarded up in a row. And nothing's changing about that. And I haven't seen a proposal that's come for a vote yet. So if you've got some ideas, I'd love to hear them.
I'm gonna give you bad news. And that's what our council will tell us, because those are privately owned, there's very little we can do. We don't have a lot of tools in our toolbox unless those owners are in violation of code, fall behind on their taxes, or want to sell them.
Almost all of the boarded up buildings are in severe violation of code.
Well, there are 2 things that are happening. One is SB 77 is just got a committee hearing, and that would, if passed, allow municipalities to create an additional tax for blighted properties. Probably won't pass.
If that part stays.
If
in,
that
yeah.
part stays in.
Is that Senator Dunbar's?
Yes, but the other thing that's happening is that ACDA is requesting a federal appropriation to buy 100 lots of abandoned properties and prepare them for development. And they're trying for that.
And we've appropriated funds, we appropriated $1.2 million to Anchorage Affordable Housing and Land Trust to leverage against its own match to buy up those properties, to fix them and put them back in service.
I want to carry on with Daniel. We're closing up here and give a little bit of opportunity. Said we could ask questions, but we've got 3 members from the public. Can I ask them if they have a comment tonight? You said I could ask a question. You've sat here for an hour and 45 minutes here. Do you have a comment?
I'll start. Kathy Bridge, President of Trinity Council. We're all pretty mature, and it's just kind of shocking because I don't know where representation is from other neighborhoods, because certainly online, and comments that PNZ received. I don't know where the representation is tonight, but I think that personally, I've heard some interesting questions from the commissioner. And I heard some interesting responses from the co-sponsors. And I'm sorry, I don't know your name, but officially it's the co-sponsor, but part of the team, part of the co-sponsorship team. And it seems like there was so much effort to refute your points versus saying, okay, well, maybe we will modify our ordinance and change this on page 5, or change this on 3 and 11. This is what we need, and we're going to try and justify it with a few exceptions, but since I don't have the latest version in front of me, believe it or not, from all this, I'm not sure when you were referencing specifics. I couldn't follow along. But I think it indicates a lot more time is needed, not only for the co-sponsors and the planning department and the commissioners to collaborate, and this was a wonderful work session that kickstarted that, then also for the public to be able to weigh in. I listened to the mayoral runoff debate on Alaska news source last Friday. And one of the questions to the current mayor and the challenger was, about the home initiative proposal. And the current mayor said, I don't know how many zoning, I don't know if we need 5 or 10 or, he's not really following that at a minutiae detail. Because he's letting the planning department do that. And then Ms. LaFrance said, she supports the general goals of the home initiative for sure. That, they both agree we're housing is needed. I don't think you could talk to anybody in town who would disagree with that premise. But she said she feels like it needs a lot more public process before it moves forward. So, I think that's where our council views it. Again, we thank Daniel and Anna. They came to a land use committee meeting last Friday evening for our purposes, and that was, excuse me, we don't do that. Anyway, it was very, very helpful. Again, it was telling us what we should, endorse versus recommendations of how it could be modified to get to the same goal that we all want to get to. That's my thing. Thank you, and thank you for asking.
A couple of questions. Your comment about you could look at this on the applied area and see how it worked out as compared to looking at the large area and how it works out. The goals are phenomenal. The need is there. It's a bit of a crapshoot. You're going to do this in this large area and roll it out. What's going to happen? We're going to find out maybe there's things that need to be cleaned up and fixed. You might get worried about more density. You're putting things on streets that can't be maintained, snow can't be cleared, and you got problems there. Maybe there's parking assignment solutions and things like that. The one thing I didn't hear tonight that I was expecting to hear, particularly if you're going to be dealing with it on the 20th, is the comprehensive plan amendments. Because I looked at that memo and I have to admit that I'm really mystified at the intent of this comprehensive plan amendments and what it's trying to do. And I think the public is absolutely completely unaware of what this comprehensive plan amendments are trying to do. And it's one of the things you're asking is give us faith so we can get this going with the comp plan amendment zoning at the same time. And it's the substance is not there for me to see. And I kind of hope there's even more explanation and more work on that as we move forward. But again, I appreciate the effort by the sponsors. I appreciate the work you guys are putting us in. This is not an easy elephant to cut up and eat.
The staff is working on the comprehensive plan case, so we haven't seen the packet. The packets will come out typically a week before the meeting, and then that will be the public hearing draft.
And thank you for pointing that out. That's just not realistic in an all volunteer public trying to follow this. It just isn't.
Yeah, you don't have to tell us that. But,
And that was another version of no shit.
generally speaking with the comp plan is I've seen it so many times where there's one side saying the comp plan says this and they list 15 different things that support their point. And then there's another guy on the other side saying, no, the comp plan says this and here's 15 parts. So the comp plan conflicts itself all day long, every day on multiple topics. So, I mean, the comp plan can say a lot, but I guess we'll see what the amendments say.
What that says.
I thought we were gonna talk more about duplexes in single family neighborhoods, but we avoided that, so I'm happy for the most part.
Why did we avoid it?
Are
we scared of it?
I'm scared of it.
Yeah.
It's the underlying premise of the proposal.
Yeah, and I guess one last thing. I hear rumors of people saying that they're gonna file lawsuits to appeal this if it ever passes. Have you guys heard those rumors?
I haven't heard them directly, but I'm very aware that that's basically the response to a number of zoning reforms in the country,
Yeah,
Not the
under
first,
various grounds.
not the first time.
And litigation is always a possibility. It takes $250 and you file a complaint. What happens then, right? You don't know what those claims are going to be until you see them.
yeah, okay.
We've done a lot as a body, and the Assembly has also done a lot in housing in recent memory. And so I think at a point, we do have to recognize that between ADU reform and the attempt at short-term rental housing reform and the changes to triplex and fourplex and R2M, there has been more progress made in recent memory than I can recall in many years. And we haven't seen more than a building season in between. So my hope is that no matter where we end up in a few years, it's more housing units.
Okay, let's
Exclusive thought.
wrap this thing up. It's like 2 hours on the dot.